Aloha and mahalo for joining Kokua Council's Honolulu Prosecuting Attorneys Candidates Forum. I'm Lila Mower, Kokua Council's president. Kokua Council is one of Hawaii's oldest advocacy organizations. We engage those who are interested in shaping the future and the well-being of our community. COVID-19 has affected our lives in countless ways, including that processes which allow for free and open discussions have been crippled. Thus, in recent months, Kokua Council sought to increase voter knowledge about this year's local candidates via live streams on our Facebook page. While we of Kokua Council rarely find it necessary to go as far as the courts to advocate, we've learned that the judicial system is our final backstop to acts we find inequitable, intolerable, unjust, or objectionable in some essential way. So it's vitally important to advocates like us that we have trust and confidence in our judicial system. On a webpage, R.J. Brown, a recent former candidate for Honolulu's prosecuting attorney, is quoted saying, "I learned that the position of prosecutor was one of incredible discretion, where decisions affected lives in the most profound ways possible. Given this, I concluded that the job must be held only by those who are decent, only by the strong, the moral, the ethical, and the reasonable. Anything less just isn't good enough." End of his quote. In the criminal judicial system, prosecutors wield a formidable amount of power. Through this debate, we hope that these candidates, Megan Kao and Steve Alm, will demonstrate their character in response to our demands for decency, integrity, and reasonableness. We hope that whoever earns the Honolulu prosecuting attorney seat will instill reforms to rebuild trust and confidence in the prosecutor's office. I'm going to switch to speaker view, everyone. So let's begin this now with a 3-minute introduction of yourself, starting with Megan Kao.
Aloha and thank you for having me. My name is Megan Kao. I am one of the 2 candidates for the Honolulu prosecutor's race going through to the general election. As I've said from the day I started campaigning, if Steve Alm is the prosecutor, the office will be a good office. And if I'm the prosecutor, the office will be a great office. Honolulu actually has a great choice between 2 candidates who are extremely qualified in their own ways. And I believe in democracy, and I believe that the voters this year are not choosing between the lesser of evils. They actually get to go out and support the candidate that they really want to be the prosecutor. And this year, they get to choose between 2 people who are highly qualified. The first thing that I have promised to do is to terminate anyone that assisted Catherine Kealoha in her misconduct. And I am able to do that because I have sat down with the federal agents. I have sat down with the Assistant United States Attorney, Michael Wheat, and I have given him information. I have brought witnesses to them. I have helped them investigate Keith Kanashiro and Catherine Kealoha. And I know firsthand knowledge who was involved in helping Catherine and Keith. There are 4 people that are currently in that office that currently have access to sensitive information, that currently have the ability to manipulate cases, and they still remain in that office. Those 4 people need to either resign or be terminated. You cannot bring trust and integrity to the office without getting rid of the 4 of those people. The second thing that I've promised to do is charge all levels of crime, enforce the law. And when I say all levels of crimes, I mean if someone breaks into your home and doesn't hurt you or your child or your grandchild, but is in arm's length reach of your child or your grandchild and steals an iPad or steals a laptop or steals a cell phone and leaves, burglarizes your house and leaves, I'm talking about charging that person. We're talking about burglary in the 1st degree. I'm talking about UCPV, which is unauthorized control of a propelled vehicle, because this increasing crime that we're seeing did not happen overnight. This is a result of the current administration's lack of enforcement for the past 10 years. And what they've been doing is not charging certain low-level crimes. The problem with this is, and I see this, I'm in the justice system every single day. I'm currently a defense attorney. I was a deputy prosecutor under Peter Carlisle for almost 5 years. And this is what's happening. A person that gets away with UCPV or burglary, they continue to commit the crime, not just once, twice, or 3 times. We're talking 10 to 20 times. They get arrested and they're released, arrested and released, arrested and released. So the next time somebody tries to stop them and says, hey, don't steal my car or get out of my house, they beat them with a bat, with their fists, with a knife, with anything, a golf club, and they become violent. And that is why we are where we are today, because the current administration was failing to charge these low-level crimes. We need to...
I'm sorry, thank you. Your 3 minutes are up. Steve Alm, your introduction, please.
Thank you, Cocoa Council, for the second opportunity to speak with you. First, I want to thank all your members. I want to thank the voters of Oahu. I was honored and gratified with the results of the primary. I was successful in all of the districts on Oahu, from Waianae to Hawaii Kai, from Pearl City to Kaneohe. The voters have spoken clearly, and they want a prosecutor they can trust. And that's what this campaign is all about, restoring trust to the prosecutor's office. The voters want a prosecutor who has proven experience, demonstrated integrity, and has a proven record of actually reducing crime. People want someone who's a successful leader, who has led a team of other prosecutors, and who has a proven record of reducing crime. I've been successful in the past as a division head at the prosecutor's office. I ran the U.S. Attorney's Office. I was then a judge for 15 years. In all of these leadership positions, I've never been satisfied with the status quo. I've always looked for new and innovative ways to make the system work better. At the prosecutor's office, I instituted a culture of high ethical standards and of doing justice, not just winning cases. I train the deputy prosecutors to be ethical and highly skilled trial attorneys, so they'd be effective in court, and also they could negotiate favorable plea agreements from a position of strength. As the United States Attorney, I led the effort working with Kalihi Palama, working with Chinatown, and together we reduced crime in those neighborhoods by over 70% in 3 years. As a judge, I presided at over 200 jury trials. I sent the violent, the dangerous, the ones who wouldn't stop stealing. All of them went to prison. All of them should be charged, as Ms. Cow pointed out. And I don't consider burglary or UCPV low-level offenses. All of those people should be charged. I also worked with Honolulu Probation to improve drug court and make our probation system more effective. I saw many, many people with drug and alcohol or mental health problems. I visited all of the treatment programs on Oahu and worked with them on how to effectively work together. We reduce victimization of crime. We help thousands of people succeed on felony probation, including hundreds of Native Hawaiian men and women. Nothing will seek a family into poverty and despair sooner than mom or dad going to prison. This really isn't a time for on-the-job training in learning how to be a supervisor or in discovering whether you can be an effective leader or not. I will hit the ground running, and I will make Honolulu safer and promote programs that enhance public safety. Thank you.
Thank you very much. Now the directors of Cocoa Council's board will pose questions to each of you to answer. Each candidate will alternate as to who first answers these questions. Steve Alm, will you please be the first to respond to this question from Barbara Service? You have 2 minutes.
Hi, Steve.
Hi.
There have been many quarantine violators, and people have heard, it was on the news, that the violators had no intention of following quarantine. Do you think that being more assertive with these violators, both visitors and returning residents, things like higher fines, a few days in jail, returning them home immediately, would be a viable deterrent to those who violate the quarantine?
All right, if we're going to do this, which we should, we have to do it right. And I think we should have identified a couple of hotels and then share the income from it with both the workers and the hotels. And then everybody who comes to Hawaii and wants to stay in a hotel goes to one of those hotels. If they say they're going to stay with friends or family members, I would require the friend or family member to be at the airport to meet them so the National Guard can check out whether this is true or not. I think it's been reported many people come here with no intention of following the rules. Also, it was a mistake early on. They were rushing through things. They're trying to get it done. Violations of quarantine should never have been made as a full misdemeanor. That gives them the right to have a jury trial. So defense attorneys are routinely asking for that, knowing it would overwhelm the system. And those cases are getting dismissed and would get dismissed in the future. If it was a petty misdemeanor with a maximum of 30 days in jail, that would not trigger the right to a jury trial, and it would be handled in front of a judge. Then that could be handled. I think people, if they violate the quarantine, should be sent back to where they came. They never had an intention of doing it to begin with. Thank you.
I'm sorry, Barbara, can you repeat the question?
Can you hear me, Megan? Oh, you would like me to repeat it? Sure. There have been many violators of the quarantine, and it's been on the news that many violators had no intention of following the quarantine orders. Do you think that being more assertive with them, both visitors and returning residents, being more assertive by fining them a few days in jail or returning them immediately to their homes would be a viable deterrent to breaking quarantine?
I mean, I can't really say what would have been more of a deterrent, but what I will say is how the cases are being handled right now. And while the majority of the people who have received tickets probably didn't intend to violate the orders were extremely vague and ambiguous, and so they were very difficult for a lawyer or a non-lawyer to understand. People would call me and ask me, what am I allowed to do? And I would say, well, this is what the order says, but the order is often self-conflicting. In addition, the news would report things either inaccurately or also contradicting. But what I will tell you what's happening with the tickets right now is it depends on which judge you get. The cases are either being pled to with a fine, and it just looks like you received a parking ticket, or they're being dismissed. And so the people that are putting forth constitutional violations and saying that, you know, my constitutional rights were trampled on, some of the judges are actually dismissing those cases. In the other instances, they're just paying a fine. It's less than $100. It's not the $4,000 fine that people are looking at, and they're pleading to a lesser charge, not the full misdemeanor.
Thank you, Megan. Steve, would you like to add to that? You have up to a minute to add to your earlier remarks.
Right. Well, I think it's one of these things we learn as we go along, but it has to be a deterrent. And if we ever hope to open it up to large-scale tourism to help our biggest industry get back on its feet, we're going to have to get our act together before that. The rules are going to have to be clear. The consequences are going to have to be clear. We're going to have to get an immediate test to allow people to come in. And then if there are violations, we're going to have to follow it up and deal with it right away. It should be a large fine. It should be something that will deter, because if you don't have deterrence for bad behavior, you get more bad behavior.
Thank you, Steve. Megan, you have up to a minute to add to your response.
I don't have anything further to add. Thank you.
All right, thank you. Rick, your question, please.
All right, so Megan, we're going to start with you. We're going to segue right into just another COVID-19 question. So COVID-19 is creating many issues for our nation and island. Evictions will eventually render many homeless, and some will resort to crime to survive. What are the what are the options, and what is the prosecuting attorney's most effective role with these kinds of cases? Megan?
Well, specifically, the evictions is a civil process that's dictated by the Hawaii revised statutes. I believe it's section 500, 560. And so that's actually a civil matter. It's held in district court, and the judges are going to decide whether or not the people can be evicted or not be evicted based on whatever allegation the landlord brings, whether it's failure to pay or violation of the lease. The prosecutor's office does not have the authority to charge or to intervene in the civil matters. If, however, there's some type of fraud going on or some type of crime, criminal trespass, whether it be a low-level, mid-level, or a high-level crime, then the prosecutor's office can and should charge it.
Okay, thank you. Steve, would you like to take that question and respond?
Yeah, I think your question was, COVID may cause evictions, people may start doing crime. One thing that's very interesting is I, as a judge and as a prosecutor, look at research and data to drive criminal justice policy. And what we've discovered over the years, interestingly enough, is even if the economy is bad, that doesn't necessarily mean people will resort to crime. You know, either people are generally honest or they're not. You know, it intuitively feels right, but that's not what the research has shown. But at the same time, if crimes are committed, the prosecutor's office will prosecute them. You know, you'll take into account, of course, the person's individual circumstances. I mean, truly, if they're homeless and they were in Safeway stealing food for themselves or stealing clothes for their kids, that would certainly be taken into account. But I have done that as a prosecutor in the past, and I did that as a judge. That is not often the case. If they're stealing from Safeway, sometimes it's bottles of alcohol or it's other things. But as a good prosecutor, you should take into account the facts and circumstances of the defendant, whether they have a prior record or not, in determining what kind of sentence to fashion if they're found guilty.
Okay, thank you, Steve. Megan, would you like to rebut?
Oh, I don't have anything to add. Thank you.
Okay. So I have a second question. So I'm, as you're probably aware, I'm the vice president here, first vice president of Kokua Council, and I have 45 years in mental health, and I used to do a lot of court stuff in Seattle with youth at risk, domestic violence, sexual abuse, things like that, and a lot of mentally ill. So I'm going to start with Steve with this question. So please discuss what mental health court is for the audience, and specifically who qualifies and who authorizes this option? How do they become qualified for mental health court? And how will you as prosecuting attorney assess this option and the outcomes of that? And then the second part of the question is just to kind of continue on with discuss other diversion options and how your office will utilize them.
Okay. We have some very good alternatives, specialty courts, where you have a smaller group of people, you have a bigger staff devoted to it. And that includes drug court, mental health court, and hope probation. And in mental health court, if defense counsel feels their client could benefit from this more wraparound service of mental health court, then they can recommend to them. One of them to go there, and then they decide. Now, one of the things I've learned is you should put your resources toward the highest risk defendants. That's how you get the best bang for your buck. That is not how the judiciary has operated over the years. So when I was the drug court judge, we changed the primary focus from low-risk pretrial offenders to higher-risk probation offenders who really needed that kind of wraparound service. And I think the same thing should be happening with mental health court and with veterans court. Just like hope probation focuses on the highest risk people. The very highest risk should be sent to by judges to prison at sentencing. But for the ones that are put on probation, we should use these alternatives to do that. And I think that's being smart on crime.
Okay. Megan, would you like to follow up with your response?
Thanks, Rick. Your question was who qualifies and who authorizes the person to get into mental health court? That was your question. And it's a process, right? So typically the defense attorney applies for mental health court and submits the application to the mental health team. The prosecutor's office decides if it wants to make an objection. And of course, there are supposed to be no violent crimes. So no assault, no sex assault. And the mental health court judge meets with the team, which includes a number of people, and they decide whether or not they're going to take the person into the mental health court. I will tell you that mental health court has changed over the past 10 years, you know, and Steve hasn't been there for almost 30 years, but it's not the same. And I will tell you that I would change mental health court the way it is now, because when a mental health court defendant violates, he or she goes to OCCC, and that's not appropriate for a mental health defendant. A mental health defendant needs mental health treatment, and OCCC is not a place for a person that suffers from a mental health disorder. And typically we're looking at schizoaffective disorder. That's the most prevalent disorder we have right now. The other programs that you asked about are, we do have some other diversion programs which are brand new, such as LEAD, Law Enforcement Assisted Diversion. And I believe that's going to be a great program, but unfortunately the current prosecutor's office is not cooperating with LEAD. And so I would definitely cooperate with LEAD if I was the prosecutor.
All right, thank you. So we're to the rebut part. So Steve, do you have a rebuttal?
Yeah, I'm curious as to where Ms. Cow gets her facts. I was actively involved in the criminal justice system, including with one of the biggest specialty court, up until I left the bench to expand HOPE, which is now in 32 states, when I went to DC temporarily. And at that time, some people went into drug court, some went into mental health court, some went into HOPE probation. And the idea of automatically excluding somebody from mental health court because they have any violence in their history, like a misdemeanor, is totally misguided. Again, those are the folks that need the help the most. You have the biggest staffs, you have wraparound services. So we did that in drug court, tremendously successful. Before I became the drug court judge, if you had a 10-year-old misdemeanor, you couldn't go into drug court, and the prosecutors would object to it. But because we had 3/4 of the new admittees into drug court coming from probation, we said, even if you have some violence in your history, we'll look at it on a case-by-case basis. Because often they're the ones who really need that kind of help. So people should be slotted into the court that helps them the most and can work with them the most. That's where you get the best bang for your buck.
Okay. Megan, you have a minute to rebut if you'd like to. Oh, you're muted. Sorry.
Yeah, I just want to explain the reason why mental health court does not take into consider violent offenders is because they have to work with the offender, right? And so the mental health court team gets concerned about the circumstances of the defendant's charge. If instead the defendant is not able to get into mental health court, he or she is able to be put on probation and get services via, insurance, or having North Shore Mental Health Assistant or other programs assistance. So they still get the services, but they don't have the team from the mental health court. They don't check in every once a month or whatever the team requires. So it's a different type of treatment.
Okay, thank you.
All right, Dale, you have your question, please.
Oh, sure. Hi there. Talking to you from Makaha. See, I'm a 70-year-old military veteran, Army. Spent 3 decades at Pearl Harbor Shipyard. So I have a simple question you can think about for a few seconds. Will this COVID-19 pandemic affect the prosecutions of your office? And if so, how? Could you go first, Dave, on this?
Okay, well, right now it's a real challenge for the system because they're not doing jury trials. And jury trials are what are the safety valve that makes the whole system work better. People will plead guilty, they'll get consequences, they can get into treatment. There's no really good supervision going on now because there's no face-to-face meetings. The probation department is just starting up trying to do that. Drug testing is up close and personal, and with social distancing, that's not going to happen. So what this requires is out-of-the-box thinking, looking ahead, and I would certainly look at opportunities to try to do jury trials in large spaces. Federal court is starting to do that. Their courtrooms are much bigger than the state courtrooms, so you can socially distance and do that. I would look at alternative venues like the convention center and other places where you could actually do jury trials. Things are being, right now the prosecutors are working from home, they're teleworking. What I would do using that situation, it's a perfect opportunity to do extensive training with the deputies. That's what I would do with the deputies right now. I did extensive training when I was head of the district and family court division. That's what leadership is. You don't just react to things, you're proactive. You train the deputies in how to be good trial attorneys, how to be ethical, and so they can be more effective in court and they can negotiate favorable plea agreements from a position of strength. So the prosecutor has to get actively involved with the judiciary, with the public defenders in figuring out a way to try to get back to normal as soon as possible. And if you can't do it close, you try to do it however you can.
All right, Megan, please.
Sure. Oh, Dale, your question was, will COVID affect the prosecutor's office and how? The answer to your question is absolutely. COVID is affecting the prosecutor's office now, and it's going to affect the prosecutor's office going forward. And this is mainly because the overcrowding at OCCC. So if you probably know, the Supreme Court just came out with 2 separate orders. One is a misdemeanor, petty misdemeanor order, and the second one is a felony order. So the petty misdemeanor and misdemeanor order basically gave a blanket release of all misdemeanor and petty misdemeanor defendants that have been sentenced or are awaiting trial. And unfortunately, they released those people without any type of supervision. The second order was the felony order, and the Supreme Court issued an order saying for certain qualifying candidates or inmates, there was an automatic filing, quote filing, it's not a real filing, but an automatic filing of release. And so each judge was to determine whether or not those felony defendants should be released. It affects the prosecutor's office because now the prosecutor has to decide which charges it's going to charge, which defendants it's going to charge. And right now, the prosecutor's office is not charging certain felony cases. For example, the police officers just called me yesterday, the day before, and there was a Class A felony, which is our highest level of felony regarding drugs, and the prosecutor's office failed to charge it because they don't want to arrest anyone and send them to OCCC. So yes, it's going to affect the prosecutor's office. My solution is that the prosecutor's office continues to charge because there's going to continue to be victims of crimes, but that the Department of Public Safety is going to have to look at other venues to house its inmates.
You want to add something?
Yes, you know, when Ms. Cow before said that the mental health court team didn't want to work with the offenders because they're violent, I can fully understand that, but that's their job. And you have a whole team that's available to do it. Because if they say they're too violent for mental health court, they don't disappear. They go down the hall and are supervised by a single probation officer in his or her cubicle. That is not public safety. That is not using our resources the right way. That's what we did with drug court. We made drug court deal with the more problematic, tougher cases, and boy, was it successful. We kept people out of prison. They were answering the questions. They were dealing with it. They were successful. It was wonderful.
Okay. Megan, do you want to add something?
No, thank you very much.
All right. Dale, do you have the next question, or shall I read it for you?
Oh, could you read that for me? The next
Sure.
question?
Okay, so the next question starts with Megan. Hawaiians and Pacific Islanders are disproportionately represented in our prison population. What should the prosecutor's office do about this, if anything?
Thank you for that question. And I accept the fact that the ACLU has come out with one study that shows that Hawaiians and Pacific Islanders are overrepresented in prisons versus in our community. But my position has always been we have to be objective and we have to be aggressive. The prosecutor cannot choose to not prosecute certain races. In other words, in order to fix that disproportionality, I cannot say, well, now I'm not going to charge Hawaiians and we're just going to let Hawaiians go. We cannot do that. That's what leads to corruption. Once one prosecutor says, well, I'm not going to charge Hawaiians, the next prosecutor is going to come in and say, well, I'm not going to charge my friends, or I'm not going to charge my family. And that leads to corruption. We cannot take that We cannot take that position. Instead, the prosecutor needs to be a community leader, go out and teach kids, be an inspiration, talk about the stories, talk about the things that we've been through, you know. And I lived on the streets of Honolulu. I was homeless for a very long time. I worked myself up, and I paid for law school by working in a number of bars. And I think that we need community leaders and people that are relatable to talk to these kids and to show them that this is not the right way. So what we can do is educate our public, educate our legislature to send money in directions that will help these things, educate people.
All right, thank you. Steve, you're next.
Yeah, clearly the prosecutor should not be treating any races differently. That's a violation of the federal and state constitutions. At the same time, we should use proven techniques and strategies that treat everybody the same, but you treat them fairly and you get good results. For example, in Hope Probation, which is caring, it's supportive, but it holds people accountable. They actually studied, Pepperdine and UCLA, how did Native Hawaiians do if they were placed in Hope Probation versus probation as usual? They were treated the same as any other race. And in fact, Native Hawaiian men and women did a lot better in Hope. They got their probation revoked and were sent to prison a full 35% less often if they were in Hope Probation than in regular probation. And because the Hope judge supervises more than 2,000 felony defendants at any one time, that means that literally hundreds of Native Hawaiian men and women have succeeded on probation and in life because they were in Hope, because of that successful strategy. If they had been in regular probation, hundreds more Native Hawaiian men and women would be in prison right now. And as I said, nothing is going to sink a family into poverty and despair faster than mom or dad going to prison for years. So we have to use strategies that will work. We have strategies that work, and we should do them. I can't tell you the number of people, as I've been campaigning around the island, who come up to me and say, Judge Alm, drug court or Hope, it saved my life. You saved my life. And I say, no, you saved your own life, but I was happy to help. So there are proven things we can do. I was proud of them before. As a prosecutor, I'll be an outspoken proponent of continuing and expanding those efforts.
Thank you. Megan, is there anything you'd like to add?
Yeah, so, Steve started that program and he's done great things for our community. He's been a great judge, a great prosecutor, United States attorney, but he's out of touch and he hasn't been here for a very long time. The way Hope Probation works now is a defendant is sentenced to Hope Probation. He is warned, he is given a color, and he has to call in 5 days of the week. And if his color comes up, he has to do a urine analysis test. What happens now is the criminals, the defendants know that they can get around the system, and so they violate in the first week. Let's say they test positive for crystal methamphetamine. They sit in the jail cell for 3 hours, they're released. The next week, they test positive, they sit in the jail cell for 5 hours, they're released. The next time they violate, they sit at OCCC for 2 days. Then the next time, 5 days. Then the next time, 7 days. Then the next time, 10 days. And these guys are gaming the system. That's what's happening right now. And they know that they can game the system because that's what Hope Probation is. The judges, the police officers, prosecutors, they're very tired of it. It's not working. That's the way it happens now. And that's why you see people with, 30, 40, 50 times they've been modified or revoked for their probation. And people watch the news and they're like, wait, why is this person out? How can this person have 10, 20, 30 convictions? And people are very concerned about that.
Thank you. Steve, would you like to respond?
Yeah, if Ms. Cow has any data or research backing it up, I'd be happy to see it. Again, as a judge, as a prosecutor, you look at data and research. The actual data we have by Pepperdine and UCLA compared the two groups, randomized controlled trial study like done in medicine and science. People in Hope Probation compared to probation as usual, they're both going to get multiple chances. That's the way it works. Do you really want to send somebody to prison for 5 years for testing positive for meth a couple times? No. You give them a sanction in hope. You get no sanctions in probation as usual. But when they compare the two, in hope, they got arrested for new crimes 55% less often than the people on regular probation. And understand, if they aren't in hope, they're going to be in regular probation. They were also sent to prison for 48% fewer days, almost half. A reduction in recidivism in criminal justice of 10% is cause for celebration. With hope, it's 55% fewer arrests for new crimes, 48% fewer days. If COVID-19 is causing problems with any sort of problems with the criminal justice system, that's something that's going to have to be worked with. But whether hope is superior to probation as usual has absolutely been proven. And if anyone has data and research to challenge that, I encourage them to bring it forward. Otherwise, I'm in the science camp and Ms. Kao is in the anecdote camp.
All right. Thank you, Steve. Gary Simon, please ask your question.
Thank you, Lila, and thank you, Megan and Stephen. I'm Gary Simon, president of AARP Hawaii, and we'll begin with Steve. And that question is, Hawaii now spends approximately $190 million per year on prisons. What will be the impact of this expense in your development and implementation of policies and procedures for charging and plea bargaining? Please, Steve.
Okay. As I said at the beginning, some people absolutely need to go to prison just for public safety purposes at original sentencing. The truly violent, the dangerous, the ones who won't stop stealing should be sent to prison. All of the crimes, all of them should be charged, but as far as prison, those folks should go to prison. But that's probably 35% of the people at sentencing. The other 65% can and should be placed on probation. And we should use proven, not anecdote, but proven strategies like drug court, mental health court, and hope probation to help reduce the number of people going to prison. Since the research shows people go to prison half as often in hope than in regular probation, that means thousands of people have not gone to prison. This isn't jail at OCCC. This is prison at Halava Women's or Saguaro in Arizona. Imagine what the prison population would be like if hope probation weren't there. So I'm going to be a vocal supporter of what research has shown has actually worked. At the same time, we need to provide research, we need to provide educational opportunities for defendants in prison. A lot of the inmates have told me they'd rather go to Saguaro and do their time in Arizona, even cut off from their families, because they can take programs, they can educate themselves. It's a crime that we send them to the mainland, but it's worse when we don't rehabilitate them here. So I would be a proponent of rehabilitation so they don't commit new crimes when they come out, and a proponent of programs that reduce the number of people going in at the front end and then improve parole so they don't go in at the back end.
Please, Megan.
Thank you. So yes, I have taken the position that I'm going to charge all levels of crime, low level, mid-level, and high level. And I can see that people are very concerned that this might increase the population of Halava and our prisons. What has to happen is the Department of Public Safety has to step up, and the prosecutor has to educate the legislature on providing more treatment. Treatment is always the better answer. So for example, Rebuttal, which is one of the best programs on this island, they don't just treat the addiction, they're treating the whole person. These guys, you have to understand, when you're homeless, you live on a couch, you grab food from a fridge, and you leave. You don't have any responsibility to clean up after yourself, to make the bed, to cook for yourself. You're very transient. And so you have no responsibilities. Habilitat now teaches the people how to have responsibility, how to sleep at the appropriate time, how to make their bed after they get up, how to cook for themselves, then clean up after themselves, how to have interactions with people at the appropriate time, how to celebrate at the appropriate time without using drugs or alcohol, and how to relax at the appropriate times, and earn the relaxation time. So And the number one key that Habilitat teaches is a trade. They learn how to do something so that they can now fish for themselves instead of stealing or eating off the street. So Habilitat, these types of programs, the legislature needs to send money to Habilitat to create programs like Habilitat, and the Department of Public Safety should implement these ideas into their integration program.
Steve, response?
Well, I'm really happy to see Ms. Cow, come around and support treatment a lot more. Habilitat's a great program. I have visited there multiple times. I've also gone to visit every other treatment program that's out there, or virtually all of them. Salvation Army ATS up in Nuuanu, Hinamauka on the windward side, Poailani Treatment Center, which deals with the dual diagnosis clients, as does Hinamauka. Sand Island Treatment Center, Queens Daycare, Ho'omaukeola for the defendants that would like a spiritual component, a Native Hawaiian spiritual component. Do your own research, call up those programs, ask them which candidate would they support, who has supported them. We get $1.2 million a year from the legislature to support Hope Probation. Guess what? We use about between $700,000 and $800,000 of it every year to pay for drug treatment. So treatment has always been a huge part of my approach to criminal justice. I will continue that as the Honolulu prosecutor. Thank you.
Megan, any response?
I will note that I have called the treatment centers, I have met with them, and I've asked them, are you supporting one of the candidates for prosecutor? And their answer is, we cannot support any candidate for prosecutor. We are a 501c3, we cannot be politically active, and we cannot be politically involved, and therefore they're not supporting any of the candidates in the prosecutor race.
Thank you very much. Barbara, your next question, please.
Is there no rebuttal?
Oh, yeah. I thought you did a rebuttal.
No. I'm not talking about a public endorsement. Ask them off the record. Call up all the treatment programs. Ask them off the record who they would support. I think you'll get the answer. Thank you.
Barbara, your question, please.
Okay, my question, starting with, we'll start with Megan, is the 2019 legislature passed a bill regarding compassionate release, whereby terminally ill prisoners would be eligible for early release from prison. How do you feel about compassionate release?
I don't disagree with anything that the legislature does as the prosecutor, and what I mean by that is the legislature is the body that makes the law. The prosecutor's office is the body that enforces the law. And so while I might have my own personal disagreements with the laws that have been passed or the laws that are currently on the books, it's the prosecutor's duty to enforce the law as the legislature has enacted it. And so the prosecutor cannot choose to say, well, just because I believe gambling should be legal, I'm not going to prosecute gambling. Just because I believe prostitution should be legal, I'm not going to enforce prostitution laws. That is not what the prosecutor's job is. The prosecutor's job is to objectively apply the criminal laws to anyone that violates the law. And the reason why I've taken this position is because if I believe something should be legal and I stop enforcing that law, the next prosecutor is going to do the same. And that's how corruption starts, because now the prosecutor becomes a political position where other people can affect what the prosecutor does. And I think that that's not fair. So that's my position.
Okay. Steve?
Certainly I support the compassionate release law. It's the right thing to do, and talk about an expensive way to try to treat somebody when they're older and they're sick. They shouldn't be in prison for that. That's a bad idea. At the same time, I have a very different view of the role of the prosecutors than Ms. Cow does. Right now, I am respected as one of the leaders in the criminal justice community in Hawaii. Legislators, city council people ask for my counsel. We talk about things. If I thought a law could be improved upon or a new law could be put into effect, I wouldn't just complain about it. I would never not prosecute it. I would go talk to the legislators. the prosecutors come up with either their own legislative package every year, or they work with the other prosecutors and the Attorney General to come up with a law enforcement coalition package where you try to make the laws better. You try to make the laws more effective. And I would certainly do that as a prosecutor. I wouldn't just take the existing status quo and think I'm stuck with that and work with that. I would try to make it better. I've done that as a deputy prosecutor, and I'll give you an example. The back when I was a deputy prosecutor, the penalty for manslaughter was 10 years. As prosecutors, we thought that was ridiculous. It should be 20 years, because the most common thing is a domestic violence homicide case. A guy kills his wife or girlfriend. The defense would always try to hope to get a lesser offense of manslaughter. Well, when it went down to 10 years, that did not reflect anywhere near the seriousness. It should be murder, but in the rare cases they can get manslaughter, it should be at least 20 years. We fought the defense bar tooth and nail with that, and we finally got it passed. Victims are helped by that. Domestic violence victims and their families and the community are helped, because as a prosecutor, you should try to go work with the legislature and the city council to make the laws better.
Megan?
Thank you. Yeah, the prosecutor should definitely educate the legislature and the city council regarding criminal matters. But for example, a nonprofit organization interviewed us and wanted me to go lobby with them. And this had nothing to do with criminal laws. They wanted a prosecutor that was going to stand behind them, go to the legislature and use our authority to get legislatures to do what we wanted them to do. And I said, listen, the prosecutor cannot do that. Any prosecutor that agrees to do that is in effect acting corruptly, because now your vote can be bought, your authority and your power can be bought, and that is not just and that is not fair.
Thank you.
All right, Helen?
Yes. I'm Helen Wagner, and a life member of Kukua Council, and serve on the board of Family Care, Hawaii Family Caregiver Coalition. Let me start. Somebody turned me off. And I advocate on senior issues. One of the things that I wanted to bring up was, what is your definition of repeated offenders? And why I'm concerned is that Hawaii is our islands, and we know everybody on the islands. Even when we see people robbing banks, somebody on the island recognizes the figures. But we have so many recognized repeated offenders. What can, and this will be aimed at Steve, what is your definition of a repeated offender, and what is your policy? What would it be with repeated offenders?
Okay, well, the Hawaii Revised Statute has a repeat offender statute that if you commit a series of crimes and you're placed on probation, if you commit another crime within the time period, you have to get sent to prison, and there has to be a mandatory minimum. So if you commit felony theft and you got placed on probation, maybe it was your first time, and then you committed another felony theft, you get sent to prison for 5 years with a 1 year, 8 month minimum. And that's what should happen to people. For the violent crimes, certainly. And as a judge, I was the toughest sentencer on the bench. And if people were specifically violent crime or sex offenders, I was the one who gave the most consecutive sentences. So repeat offenders are people that just won't stop committing crime. And unfortunately, some people just don't get it. They're dangerous. They need to be removed from society and sent to prison. But again, the good news is that that's probably 35% of people at sentencing. And the deputies should be encouraged to identify those folks and go after them hard so we can try to get them put into prison.
Okay, thank you. And now, Megan.
Thank you. A repeat offender is defined by Hawaii Revised Statute, Section 706, 606.5, and it is when somebody commits a crime and then commits another crime within a certain window. So for example, let's say somebody in 2000 is convicted of manslaughter, and then he goes to jail and he comes out in 2011 and commits another crime. If he's convicted of that second crime, he now has to serve a mandatory minimum term of imprisonment. That means he has to serve a certain amount of time in prison before he can be considered for parole. And in this example, it would be 6 years, 8 months. The statute lists the certain crimes that qualify under the statute and the certain amount of mandatory minimum terms. So what that really means is the judge sentences the person to prison. The person does the mandatory minimum term, and let's say it was the 6 years, 8 months that I just described. He cannot go in front of the paroling authority until the 6 years, 8 months is finished. Once the 6 years, 8 months is finished, then he can go to the parole board and say, hey, parole board, I want to be paroled. Now, the parole board can either deny the parole or can grant the parole, as long as the mandatory minimum term of prison is served.
Thank you. Thank you. And Steve?
Nope, that's the folks that commit crime, commit other crime like that. Some crimes, they should go to prison the very first time. Not everybody deserves, to get a shot at probation the first time, but for some other crimes, if some judge decides to give them probation, but if they commit another crime, they're going to end up in prison, and that's where they belong. And again, we got to make prison more rehabilitative. We got to make it more effective, because the job of prison is public safety, and public safety means thinking about an inmate's release from the day they're in there, to try to make, it isn't just to house them and so they can sit around and talk about committing crime or getting high. The job is to give them education opportunities so the ones that want to can take advantage of it.
Thank you. Megan, you're okay? Thank you.
All right, Lourdes, you're up.
Hi, I'm Lourdes Scheibert. I'm a volunteer director here at Cocoa Council. I also am an advocate at the legislature for seniors' property rights as condominium owners. So my question for Megan is cash bail, for or against, why or why not?
Thank you. Cash bail is an amount of money that.
One moment, there's a lot of static. I'm sorry, I don't know why, but can't hear you now. Now I can. For some reason, there's quite a lot of static, but let's try.
Okay, so just let me know if it gets bad, but cash bail is an amount of money that a defendant has to pay in order to get out of custody before the trial starts. So the way it works is the prosecutor gets to argue for a certain amount of bail and gets to say, we want $20,000 bail because the defendant has a prior record, is likely to reoffend while in the community, or he's a threat. The defense counsel then gets to get up and ask for their position and say, well, judge, we think the bail should be $1,000 because my client doesn't have the financial means to pay, and he's going to go to treatment despite his prior record. The judge then decides, considers the prosecutor's argument, considers the defense attorney's argument, and then decides. So let's say the judge sets the bail at $10,000. There's two ways the defendant can get out of jail before the trial starts. Either number one, pay the $10,000 cash to the court, which he will get back if he comes to all of court hearings. Or number two, post a bond by hiring a bond company, typically for 10%. So he pays the 10% to the bond company. The bond company puts up a bond, and then the bond company now regulates the defendant, make sure he comes to court, make sure he's checking in with the bond company, make sure he's not getting into trouble. So I support the cash bail system because in December of 2018, The court, Judge Shirley Kawamura and Judge Ron Schrader, drafted a report to the legislature that said that we are complying with the bond rules or the bail laws. We have a good system, and the Oahu Intake Service Center is not set up to get rid of cash bail at this point in time because it lacks resources. So if Hawaii or Honolulu wants to get rid of the cash bail system, the legislature will have to give the Oahu Intake Service Center, which is a part of the Department of Public Safety, additional funds to have officers that can monitor the defendants.
You're up next, and Megan, just before Steve goes on, we still did get a lot of static from you, and it could be your where you are in terms of vicinity to your microphone. But anyway, Steve, if you could respond, please. Thank you.
Certainly. Yes, I think we should change the system. Cash bail currently rewards the wealthy who can pay the bill, pay the bail, and it hurts the poor who can't make that bail.
Right.
And one of the worst parts of it is the people that need it most aren't actively supervised. You could have the biggest methamphetamine user on the island, and if his bail is $5,000 and he pays it, he's not going to be observed. He's not going to get drug tested. He doesn't have to show up to see his PO. But as one who's been involved in the system for a long time, I realize that you change one part of it, you're going to affect the rest of it. So the prosecutor should be at the table working with the judiciary, working with the legislature to come up with an alternative. And you don't get rid of cash bail until you have an alternative in place. But that means you're going to have judges available to deal with people that are arrested. You're going to have alternatives like release on only target. You're going to have things like a signature bond. And you are going to have to get funding so that some group, whether it's Intake Service Center or other, can actively supervise people. The Washington, D.C. Pretrial Services Agency is a very good example of it, but they have money to help people with treatment pretrial and to actively supervise them. If you have that whole system in place, you can actually supervise people, they'll show up for court, and they'll get better. We actually did a research project with Berkeley, University of California, Berkeley, and University of Chicago, using the HOPE strategy in the pretrial context. It worked tremendously well, giving people sanctions immediately. And the HOPE group got arrested for new crimes, new felonies during the pretrial period, 42% less often. But we had money in the program for treatment, outpatient and residential. So yes, cash bail should be replaced, but not until you have a very good system set up, not until you have money to help monitor people the right way and provide the services they need. Unfortunately, with the COVID crisis, that's not going to happen anytime soon, but it absolutely should be something we keep an eye on, and we do as soon as it's available.
Megan?
Can you hear me?
Yes.
Okay, so, people often say the cash bail system provides two systems, one for the poor and one for the rich, like Steve just said. But I would really strongly recommend that you refer to the Hawaii Criminal Pretrial Reform. It was the recommendations of the Criminal Pretrial Task Force to the 13th Legislature of the state of Hawaii. It's dated December 2018, and it talks about how our judges in the circuit court now, within 2018, Steve was gone already, so I know that he hasn't been there. He's not relevant at this time. Things have changed, and this report talks about how the judges are doing a very good job of paying attention to these issues so that there is no two systems, one for the rich and one for the poor. It is a very well-written report.
Steve?
Well, I actually talked to Judge Trader when he was running the committee, and we shared ideas of it. And and they took smaller steps and talked about giving the judges more authority in certain areas. But the fact remains, and judges all along have taken certain things into account whether it's financial resources, whether it's history. They've always done a good job, and I hope they'll keep doing a good job in the future, but it doesn't change the basic part of it. If you have money, you get out. If you don't get out right away. Down the road, your defense attorney, like Ms. Cow, can file a motion for supervised release and try to get you out, and the judges can consider things.
Thank you. On my second question, we start with Megan. Tell us your thoughts about civil asset forfeiture.
I think that the civil asset forfeiture has not been handled well for probably a while in the prosecutor's office, and it's probably for multiple reasons. The prosecutors typically are involved in criminal law. They're not trained as civil litigants. The civil asset forfeiture statute is a civil process. Like Steve mentioned, I'm a criminal defense attorney. I'm a civil litigator, a CPA, certified public accountant that's non-practicing. And so I've had all of this experience. I look at everything from every angle. And I will tell you, there's an issue that the civil forfeiture laws are not being used correctly. I do disagree with the way the current administration was using the civil forfeiture as a sword instead of using it as a legal basis. The current administration was going after certain people's property and not charging them, and I think that's a huge injustice, and I would correct that.
Steve?
Well, the devil's in the details and how well people are following the rules to do it. I can tell you the day I was sworn in as United States Attorney, I was visited by the Downtown Neighborhood Board, and they told me there is a bar on Smith Street that is selling crack cocaine all day, every day. They have talked to the prosecutor's office, they talked to the police, they talked to the Liquor Commission, to no avail. And so we decided we would get involved with it. We would try to see if there's anything we could do. And we discovered HBD had identified the owners of the bar through the tax map keys. They had sent them letters for years talking about the arrests they had made in and around the bars. This single bar, the Golden Star and the Escalator, it was later changed, the name changed to Golden Star and Escalator. But the building owners intentionally stayed away from the bar. They just collected the rent. And it was a crack house. People would walk in, they lay the rocks on the bar, people would choose them. And so by filing a lawsuit, following the rules, we were able to shut down that bar. And it led me to learn how to work with community. And the net result is the building the bar that was in is now a police station in Chinatown. So it went from a crack house to the police station. It doesn't get better than that. So the way you do things, the way you follow the rules, you file lawsuits, that's the way I do it if I were Honolulu prosecutor. And I've had success before, I'll have success again.
Megan?
Thank you. I don't have anything to add.
All right, thank you very much. Doug, your questions, please.
Okay, first, mahalo both to Steve and Megan. I'm H. Doug Matsuoka. I'm a volunteer director here at Kokua Council, also the IT guy for Hawaii Meals on Wheels. That's the other Meals on Wheels. And also founder of Hawaii Guerrilla Media Hui. This question goes out first to Megan. King Kamehameha's Kanawai Mamalahoi, the law of the splintered paddle, is enshrined in Hawaii's constitution. Should it affect the practices and policies of the prosecutor's office? And if so, in what ways?
Sorry, but I'm not familiar with that. Can you explain, please?
Yeah, it's a law very briefly that says Kamehameha demanded that people respect alike, both great people and small people, and that made it possible for everyone, both the old men and women and children, to be free to lie on the roadside without fear of harm. and under pain of death. And this was directed toward the ali'i and was the first law that prohibited the abuse of power. And it's quoted much now, particularly in homeless rights and sit-and-lie laws and that sort of thing. So I just ask if it should have an effect on the policies of the prosecutor's office.
So my position has always been that we have to have an objective yet an aggressive office. And when I say objective, it means that we cannot choose who we prosecute. We cannot choose what levels of crimes that we enforce. We have to enforce the law against rich and poor, against Hawaiian or not Hawaiian, against local or not local, against homeless or not homeless, you know. And part of the problem is people are saying, well, you know, someone's homeless, we shouldn't charge them. But if they violate the law, we have to charge them just as we would anybody else. But we have to get them treatment, and mental health treatment is very difficult to understand if you've never been through it. So, you know, I have helped treat many family members, clients. You know, being a defense attorney, I get to see how mental health illness really does affect people. And when there's an organic disease, for example, organic schizophrenia, and the person is self-medicating, we have to pull together as a community, as a family, to get the person treatment. And it's ups and downs and ups and downs and ups and downs for life. It doesn't ever go away for the treated person or for the family. And so I believe that we have to be objective, but provide the treatment that everybody needs, whether it's mental health treatment, drug treatment, housing, life skills. And so the prosecutor has to be an active voice in educating the legislature to get that done.
Thanks, Megan. Steve, any rebuttal to that?
Well, my response to your question is the law of the splinter paddle at heart is about fairness. And I don't think the sweeps are helpful. It just moves people around. At the same time, many people that are chronically homeless have drug and alcohol problems. And instead of seeing it and just thinking, wow, that's a problem, and waited for cases, I worked with Honolulu Probation, and we devised Hope Probation from scratch. And as you've heard, people in Hope get arrested for new crimes half as often as regular probation and go to prison half as often. We use most of the money we get from the legislature for treatment. And so the leverage of the criminal justice system can be a real help to people in drug court, can be a real help to people in mental health court and in Hope Probation. And I plan to, you know, since I know those programs, I worked with them, I visited all the drug treatment programs, I know the people there, I will be a full partner with them in expanding that. And I think more folks, because you could take somebody who's homeless and put them in an apartment, but unless you deal with the behavioral health issues, you're not really going to help the person. You know, I'm excited about the little villages of small houses, and if you can put the services right at the village, that's great, because you've got to make it work or it's not going to happen. And substance abuse, the dual diagnosis programs, and the leverage of the court to help people can all be tremendously helpful. Imagine having a prosecutor who doesn't object to anything, it isn't a roadblock to anything, but is an active voice working with the others in collaboration to make things better. That's what I'll do.
Thanks, Steve. Megan, do you have anything to add? Or?
No, I don't have anything to add. Thank you.
Okay, thanks. You're not rid of me yet because I have another question. The Honolulu Prosecutor's Office works closely with the Honolulu Police Department. What measures should the prosecutor put in place to ensure that HPD will not exert too much influence over the prosecution of crimes committed by police officers? And this goes first to Steve.
Okay, I think the proof's in the pudding. Megan and I both, you know, fought for and interviewed a couple of times with SHOPO, with the police, to try to get their endorsement. And, you know, they knew I had done this kind of thing before. They knew I was an effective leader, that I could organize the office, get it back in shape. But at the same time, they knew as the United States Attorney, we had prosecuted police officers for civil rights violations, for corruption. I had actually done that. And they went to prison for years. So you've got to have enough stature, you've got to have enough authority to say nobody is above the law. I said that all the time when I was U.S. attorney, when we would prosecute white collar criminals. You know, when we prosecuted all these political folks, you know, whether it was Gary Rodriguez, whether it was Marigatani, whether it was Danny Quijano, you know, they were powerful, entrenched people. So what? They were the people we heard criminal stuff about, and so we prosecuted them. So the police know they're going to get a tough prosecute with me. They're not going to get cut any slack. If they committed a crime, we will prosecute it. And they respect that. And in spite of that, they still endorsed me because they knew I could do the job and would not be subject to any pressure.
Thanks, Steve. Megan?
Thank you. So police officers are and should continue to be charged just like non-police officers. We go back to objectively applying the law against all people, including police officers or not police officers. But what I would also do is, you know, the lines of communication between the Honolulu Police Department and the prosecutor's office have been severed. The current administration was not working well with the Honolulu Police Department, and in fact, Susan Ballard issued an internal memo prohibiting Keith Kaneshiro from attending any of the crime scenes, which he shouldn't have been there to begin with, quite frankly. But they need to train the police officers. People don't really understand that police officers are not lawyers. They're not trained in the law. They're not trained in the nuances of how the justice system works. And so in addition to making sure that police officers are charged, the prosecutor's office should work with the police department to have annual training regarding the laws and how to enforce them.
Thanks, Megan. Steve, anything to add?
Yeah, well, Susan Ballard went beyond that. She refused to have Keith come to meetings that would talk about intelligence and, you know, secret matters because she didn't trust him. The police department would trust me. I have spent 31 years as a prosecutor and a judge, and I know how to keep my mouth shut. I've either been a prosecutor or judge the whole time. They will trust me to follow through with doing that and keeping secrets and otherwise. And training shouldn't just be an annual affair, although I have gone for the last 20 years to the police academy to train the officers in being upright, in doing the right thing. When I was head of the district and family court division at the prosecutors, we trained every class at the recruit class to be ethical, to be honest witnesses. We had them in district court and we cross-examined them and talk about the importance of being honest. Joint training between the prosecutors and the police is a key part to it, because we ask the police to do a lot of difficult things. Any police officer who shows up at a domestic violence scene essentially is being asked to be a detective, gather evidence, you know, do that kind of stuff. They don't get trained in how to be a detective. That's later on. We've got to train them to be detectives from day one at scenes like that.
Thanks, Steve. Megan, any final word?
I will note that Keith Kaneshiro and Catherine Kealoha are an aberration to our system. They are not the norm. I believe, and I think Steve would admit, that anybody that's the next prosecutor will be able to work well with the Honolulu Police Department. Keith Kaneshiro's federal investigation really put a damper on the prosecutor's office and, of course, gave Susan Ballard pause to allow him into the meetings and to come to the crime scene. But I don't see neither Steve nor myself in that position.
Thank you. So we have a little bit more time than I anticipated, so I'd like to ask a question too. We often hear about plea bargaining, about the ability to charge someone with a lesser or greater crime. Starting with Megan, what are your thoughts regarding plea bargaining?
Plea bargaining is necessary in the criminal justice system. There is not one prosecutor, not one defense attorney, not one judge that would disagree with that statement. And quite frankly, I mean, I can't give you an actual statistic, but based on my experience in the criminal justice system for the past 14 years, I would say 90 to 95% of criminal cases end up in plea agreements or plead to the charge that they're charged with. It's only a small amount of cases that go to trial nowadays, and that's for various reasons. You know, people want to accept responsibility, and so let's say they're looking at a crime that doesn't allow probation, but they don't have a history of crime, and they are willing to do treatment. The prosecutors will often offer them a lesser crime to plead to. And this benefits everybody because it doesn't re-victimize the victim. And I'll tell you, going to trial with a victim having to testify in front of 12 people, 12 to 13 or 14 people, the jurors, a judge that person's never met before, being cross-examined by a defense attorney, that's very, very stressful. And so if we can avoid that, the victim avoids having to testify and be re-victimized. The defendant gets a bargain because he or she gets to get treatment, which is always the better thing, then everybody wins. And so plea agreements are necessary.
Thank you. Steve?
I agree, or its equivalent inclination about things. When I was on the bench, the attorneys would come in front of me, and by rules, the federal judges can't engage in plea negotiations with the two sides. The state judges are able to. So often that's what happens, working together, trying to come up with something. What I would, my practice was the prosecutor and defense counsel would come in, they would tell me about the case, the strengths, weaknesses, and then I would give them an inclination of what my sentence would be if the person pled guilty. If the defense and the defendant thought that was fair, the person would enter a plea. We would do that in open court. I would put my inclination on the record, but I would also, you know, just so it was there so nobody could forget about it later. But that required, as the facts I knew them then, if the defendant had told his attorney that he doesn't have a record on the mainland, and then the pre-sentence report that's done in every felony case before sentencing, if that's done and it shows a bunch of, you know, felonies on the mainland, I would probably disregard the inclination I gave, and I probably would send that person to prison. But at the same time, whatever inclination I would give would count whether they pled guilty or went to trial. I'm not going to punish a defendant by exercising his constitutional right to go to trial. So that did, as the toughest sentencer in the courthouse, that did mean I probably did a few more trials than if I gave everybody probation. But for a number of the cases, I said, you know, this guy needs to go to prison. He's a danger. And in some cases, I might send him to prison for a consecutive sentence because they really are a danger to the public. But you want to be as transparent as possible. I agree with Ms. Cow that you need, you know, there has to be some way to deal with the massive cases. You just have to do it in a fair, equitable, transparent way. And I think I was able to do that as a judge. And for the prosecutors, if I was Honolulu prosecutor, I would get the prosecutors to focus on the really violent, dangerous, the guys who won't stop stealing, and try to send them to prison at sentencing. But for the rest of the people, if they deserve probation, ask for probation. For too long, the prosecutors have felt they had to go into court and ask for prison all the time. Not only does that hurt their credibility with the judge, but because they sound like a broken record. I think if they were honest and able to be honest about it, ask for prison for the folks that need it, ask for probation for the folks that should get that, they might have more credibility. They wouldn't be crying wolf, and then they might be more successful in sending the people to prison who really need to get sent there at sentencing.
Thank you. Megan, do you have anything to add?
No, thank you very much.
Thank you. Steve, did you want to add any more? You have up to a minute.
Just that, you know, other candidates over the time, you know, point to problems in the system. Clearly they're problems, and we have to work on those problems. But we have overall, I think, a good system, and we should try to do whatever we can to make it better, to make it fairer. We have a good public defender office. They represent their clients. We have a good defense bar to represent them. I think the prosecutors could use some more help, could use some more time, more training, and then stay at the office and not quit. And so they can develop into the very, you know, the real elite of trial attorneys, but that takes years as well as a lot of training.
Thank you. Okay, in a few minutes, not now, I'm going to give you time to do a closing statement. So this is going to be the last question where you can go back and forth. What do you want to address about your opponent's positions? Steve, let's start with you.
Well, you know, I think when Ms. Cow talks about charging everybody, if it's a legitimate case, I can't think of a good prosecutor who's not going to charge UCPB, who's not going to charge burglary, who's not going to charge theft, because it's absolutely true. If people get away with stuff and they're not prosecuted, that's a problem. And I think part of it, maybe has heard the same complaints I've heard from police officers about cases not being accepted by the prosecutor's office. That is something that would absolutely have to be looked at, because police officers stop me on the street. I'm filling up gas. They come up and complain to me about certain cases not being prosecuted. So I think when Ms. Cow talks about, she's the candidate that would charge cases, trust me, I'll charge them too. At the same time, the police officers usually get it right, but not always. We're the lawyers. We will decide at the prosecutor's office whether there are the elements, whether there's proof to prove the case. And it wouldn't be right to take a case if there isn't proof there. There's a whole screening section that will evaluate the case, should do it fairly and accurately. If the police need to do more work, they send them back to do follow-up work. And in some cases, that solves it. In other cases, it's still not enough proof. And then you have to tell the police, we're not going to prosecute that case. I'm sorry. We did that when I was at the prosecutor's office before. I personally turned down cases. When I was U.S. attorney, we did the same thing. We turned down some very high-profile cases because we weren't convinced we could prove it beyond a reasonable doubt.
Thank you. Megan, your response, please.
Thank you. Like I said earlier, and I've said this since we announced a year ago, if Steve Alm is the prosecutor, it will be a good office. And if I'm the prosecutor, it'll be a great office. I mean, we are both qualified. We have very similar ideas, some that differ. But I will say this, when Keith Kaneshiro came in to the office in 2010, he had been out of that office for 14 years. And so his colleagues, the people that he came up through the system with, the people that were his friends and close companions, they had been out of the system as well for 14 or plus years. And so Keith brought into the office a very old way of thinking, very old school ideas. And the people that he brought in were no longer qualified to be at the prosecutor's office because they had been gone for so long. They were no longer trial lawyers. It takes a lot of energy to do trials. And the reason why I left the prosecutor's office is because Catherine Kealoha was my supervisor. And I was trying to tell everybody, hey, she's doing things that are unethical, but no one would listen. So I was forced to resign within 3 months of Keith Kaneshiro and Catherine Kealoha coming into the office. And the only way to continue to do big trials and take big cases is either number one, to be at the prosecutor's office, or number two, to open your own practice. And I could not be at that office. And so being relevant and being a trial attorney is extremely important. And you have to be able to cross-examine a defendant to know what he or she is thinking and to be able to get him or her to admit things. And if you haven't done a trial for 20 years, you're out of touch and you're not relevant anymore. Juries change, the criminal law changes, jury compositions change, jury expectations change within a span of 5 years, let alone 20 years.
Thank you. Steve, would you like to respond?
Sure. Fortunately, nobody's running for this who hasn't done a trial in 20 years. The last jury trial I did was 8 years ago. And the reason I love doing trials, like I said, I did 200 of them, making sure there was no prosecutorial misconduct, keeping the attorneys in line, ruling on evidence. But we were so successful in changing the way we did probation, and we were keeping so many people out of prison that's where they wanted me. I took over the probation work for most of the other judges, and it was reducing recidivism by 50%, which is unheard of in the criminal justice system. That's why 33 states have started programs based on hope, and one territory in Guam. It's being used in parole. It's even being used in prisons to reduce their assaults and their use of solitary confinement. I absolutely would only pick trial attorneys to be supervisors of trial divisions. I think that was one of the problems with Kathy Kealoha being placed in that position, because that tests you over the years in doing it. And I did training for the attorneys. I'll keep doing it, but I'll do it with all of my supervisors too. And so many of the leading defense attorneys in town have volunteered to help come back to the office and do training if I get in as Honolulu prosecutor. So thank you very much for the question. I think it's a good one. I think there's so much that needs to be done, and I hope to be given a chance to do it.
Thank you, Steve. Megan, would you like to respond?
Sure. It's very different doing a trial versus being a judge and actually just watching the trial. It's very different. Being a trial lawyer really does take a lot of energy out of you. You're prepping, you're arguing, you're appearing in front of a jury for 8 to 10 hours a day you're working. It takes a lot of energy. And, for example, the Christopher Dede case, that case was tried by a deputy who hadn't been in the office for over 15 years. And now we've come to the position where they can only ask for an assault 1 after the defendant had been charged with murder in the 2nd degree. And so, the office failed the victim of that case because they should have put forth a better trial attorney, someone that was relevant, someone that could appeal to the jury, and I have done, as a practitioner, more trials than Steve in the past 14 years. Being an advocate is very different than sitting on a bench and being a neutral. It's very different. So I do reiterate, Steve will be a good prosecutor. I will be a great prosecutor.
Thank you very much. This has been a great educational experience. Now each candidate will have...
A rebuttal?
Oh, go ahead.
If Ms. Cow seriously thinks that all a judge does in court is watch a trial, that's a myopic view of things. The judge is the one who leads the jury through the whole process, explain it to them. There are thousands of jurors out there in Hawaii now who know how I run the courtroom. The prosecutor puts on the evidence. They bring the witnesses, they bring the police officers, they bring the victims, they try to protect them. Defense attorney tries to disparage them, cross-examine them, keep the victims essentially from going for their justice and getting their day in court. That's not me at all. I have spent 30 years protecting the citizens of the state of Hawaii as a prosecutor and as a judge. I'm very proud of my record, and I look forward to leading the prosecutors in the future. Thank you.
Thank you. Megan, would you like to add anything?
No, thank you very much.
All right. And going back to what I was saying, each candidate will have 3 minutes to provide a closing statement, starting with Megan.
Oh, thank you. So this has been an extraordinary experience for me. I'm so happy to have run. It was a very difficult decision for me to make given my history. I've told you folks in our first session that I lived on the streets from very young. My parents suffer from drug addiction, alcohol addiction, and mental health issues. And so, I had to fight for myself to get where I am. And I'm so excited about this race. And Honolulu has a choice, and I believe in democracy, and I believe Honolulu will make the right choice. And I will leave you with this one story. I was walking down the street, Bishop Street, the Friday before the primary election, and I ran into one of the deputy prosecuting attorneys. And he's an experienced attorney, and he has no reason to talk with me or to tell me what his thoughts are, but he says, we're all very interested in this election. And I said, oh, that's good. I hope you guys, talk about it, share your ideas with people. And he said, do you want to know what we say about you? And I said, okay. And he says, this is what he said. I'm quoting him. How freaking awesome would it be to have Megan Cow walking down the hallways with us, fighting in the trenches with us? It would be so amazing. He said, I would just want to be a gopher. And I said, you are not a gopher. No one would be a gopher. Everyone would have their place, learn, have great experiences. And I tell you this story because we have a chance to move forward. Steve has given to the community. He's been a great force in Honolulu, but it's time to move forward. It's time to give people hope. You know, I can talk to people and I can explain where I came from, where I've lived. I mean, people would be shocked if they knew, you know, the houses that I lived in, the streets where I lived, the people that I hung out with. You know, my friends are not rich, educated people. My friends are the people that were living on the street that had drug addiction, but that pulled themselves up and own businesses and love their community. So Honolulu has a choice, and I think it's going to be the right choice either way. Mahalo for having us.
Thank you, Megan. Steve, your closing statement, please.
Thank you. This election, as I said at the start, is about restoring trust to the office. And who does the public think can be the one to do it? As I have heard over and over from people saying, you'll bring proven leadership there. Yes, you've been around for a while, but you've been successful at all of those stages. And I pride myself on being open to new ideas and innovative solutions and looking around the country for them, but also in creating our own innovative solutions and coming up with things that work well. And I think the voters want to find who is the successful leader, who's actually done this, who has led other prosecutors, who has the stature to work face to face with the police chief, with the US attorney, head of the FBI, the attorney general, who can relate to them as a peer in trying to do this, who has gone to the legislature, who has gone to the city council and has their respect in doing things, who has actually reduced crime. When I was US attorney and we talked about weed and seed, a 70% reduction in crime in Kalihi, Palama, and Chinatown. That's 7,600 misdemeanors down to 2,400, 3,000 felonies down to 750. That changed the character of those neighborhoods. And the renaissance in Chinatown with bars, restaurants, never would have happened without the community coming together and with the help of Weed and Seed to make it safe for local people to park their cars again. So Ms. Cow is passionate. I get that. If she wants to apply as the deputy prosecutor, I would certainly consider any application for that. It's really good. I love doing trials as a prosecutor. I did 5 murder cases, 5 times more than she did as a prosecutor. But the job is more than that. There should be deputies in the office who want to go to trial and want to do that. We'll help train them and get them to do it. But as prosecutor, I will certainly make that office into the best place it can possibly be. So I thank the Ku'uku'u Council. It's been great to speak to you again. Thank you.
Thank you very much. Mahalo for participating in this debate. Megan Cow, Steve Alm, it was wonderful to have you both here again. Ku'uku'u Council hopes that we've made it easier for our community to select the best candidate to represent our needs in the Honolulu Prosecuting Attorney's Office. It really was a pleasure. It was an exciting forum and debate. As a reminder to the audience, please be sure to return your general election ballots as soon as possible so that your vote counts. Ku'uku'u Council invites you to watch another debate. This will be between the mayoral candidates Rick Blangiardi and Keith Amamiya on September 14th at 11 a.m. We also invite you to join us when we host our annual legislative wrap-up via Zoom in early October. To the audience, to Steve Alm, Megan Cow, and to the Ku'uku'u Council board members, mahalo for joining. Malama pono, stay safe, aloha. Thank you.
Thank you. Mahalo.
Stay safe. Mahalo.
Stay safe, everyone.
Aloha.